Hi, this is James Eng with Old Capital, and today I'm here with Gene Trowbridge. Gene, thanks for jumping on and coming on so we can learn a little bit more about PPMs, 506B, 506C, all those acronyms that people in the business know and people outside the business are always confused by. So I appreciate you jumping on and wait, maybe to start off, maybe just give people a little bit of your background and then we'll jump into some
Sure.
of the questions that I have here.
Sure. Well, this is a great opportunity for me. Thank you very much. Thank you very much, James. Probably what's most important about me is I've been in this business for a very, very long time as a commercial broker, commercial real estate broker, and then as a syndicator. I was a syndicator for about 20 years, put together quite a few offerings on primarily building self-storage through the three-county Southern California area. And at one point in time, I decided I'd had enough of my line is the care and maintenance of partners can drive you crazy. And this was long before there were any back office companies to help me with the management of the partners. So I went to law school at 45. And so I was going to do that for 15 years until I turned 60. And I've been doing it now for 27 years. So my hashtag is not retiring. Okay, that's it. So my strength is my practical experience in the business as a syndicator, combined with my legal knowledge, and that's what I do. Is I write for clients. So that's it.
So I met Gene probably for the first time maybe 4 or 5 years ago, and we'll talk about this, but this is the third edition of the book. So I still have it. I mean, this is through a couple moves and everything. So I think it's a great resource and something that everyone should pick up. So we'll have a way for people to get that sort of at the end of the
Yep,
talk. So
the fourth edition is out. The fourth edition has been updated. Chapter 5 really is the issue with all the securities law changes that have happened since the third edition. So we'll be able to give everyone a PDF at the end, because at the end of this session.
okay, all right. So maybe let's just start at the beginning and then we'll get into
Okay.
some of the nuances. It's just sort of like when do I call you? Like in terms of when should a syndicator really engage their attorney? And then let's just talk through that process.
Well, first of all, I get a lot of what I call homework calls. People calling and saying, I'm about to do this. I'm thinking about doing this. I thought I would reach out to you. Let's talk about how this goes. So I'd have the same conversation with them that I'm going to have with you right now, James. Most of the time, our clients call me when they have an LOI, an executed LOI on the property, and they're going toward the purchase and sale agreement. That is enough time for me to get started. There are all sorts of things I can do at the beginning of the preparation of the offering, so we can get a head start on this. It takes 3 or 4 weeks, especially on the first offering with the client, because they haven't seen the documents. They read them, we talk about it, we edit things. It takes 3 or 4 weeks to get your work done, so we might as well get started as soon as possible. So that's, other than the homework call, which I always welcome. I take everyone's calls and talk about this. And then when you're really ready to get going, we start with the LOI. Now, some people, as you know, James, probably don't use an LOI. They go right to the purchase and sale agreement. Well, that's right. But as soon as you get that done, you need to start with me. The people that have trouble are the ones who wait too late. They wait to get the financing and then they call me and they're 2 weeks from the close. That's not going to work. That's just not going to work. I have to turn some of those people down because we just can't get it done together.
So we always have like I have a probably a checklist that I send to borrowers when they want, let's say, a quote on a deal or even submitting a loan application. What is sort of the 4 or 5 things that you need from the borrower to even complete a PPM? So let's say the LOI signed, they send it to you and they're like, okay, now we've got to make this PPM. What are the main things that you need that are more the lead time items? Because sometimes people come to me and they're like, well, I'm doing my webinar, but I don't have my documents yet. And I'm like,
Isn't that great?
well, yeah, and I know it's, attorneys are busy, everyone's busy, but what's maybe the top, let's say 4 or 5 things that they need to just get to you to make that PPM?
Well, in my firm, I have a strategy. You sign the fee agreement with me, James. You send me my fee, and the first thing I do is, this would be on a specific property offering. The first thing I do is I have what's called a deal structure interview. So I'm on the phone with you, and it probably takes a half an hour to go through all the questions I need to get started. And some of the things that I need from you would be, what names would you like to use for the LLC that's going to own the property? And what name would you like to use for the manager LLC? Those are important because I can get those LLCs formed right away, and then you can get your tax ID number and you can get ready to open your bank account. That's important. The main thing that's important on a specific offering, James, is at least a draft of the property package. What is it you have, pictures and demographics and all that? What is it you have that you're going to give the investors so that they can look at it and make some determination if this is a project they might like? And what I find is early on, the client doesn't have that finished, but they have enough information. The property address, the price, maybe even a sources and uses page. That's pretty important. What are you going to do with the money that you raise? How much do you need? Do you have a plan for your distribution pattern?
Okay. All right.
And what do you have about financing information? Do you have a term sheet?
Right.
So I think it's the property pack, it's the names that you want, the property package, some start on sources and uses, a plan for your distribution, and your term sheet.
Okay, that's perfect. Like we've been doing a lot more bridge loans in the last probably 3 to 6 months, and some of these bridge lenders want LLCs formed in, like, let's say you're buying property in Texas, but they want the LLC formed in Delaware
Sure,
or
absolutely.
some other place. This wasn't in our prepared questions, but I'm coming up with questions as we go. Why does that even matter? Like, why does the lender care about where your LLC is formed?
Okay, to make a really long answer short.
Yes, please.
Delaware has an extremely well established LLC set of laws. They even have an LLC court. Okay, they are the most sophisticated and most advanced place for LLCs, and the lenders want that for their protection, so that if they have to go after the property, they know exactly what the rules are. Now, I'm not saying that there's anything wrong with going to Wyoming or Nevada or whatever you get, but they don't have quite the same structure that Delaware does, and the lenders are familiar with Delaware. In fact, most lenders are formed in Delaware themselves. So that's just what it is. But the problem here, not the problem, but the issue is, you get formed in Delaware, and now you have to bring your entity into Texas and form it as a foreign entity. So now you've got two things going on. Well, that's kind of one of the questions that is one of the questions I asked in the deal structure interview, have you talked to your lender, and are there any requirements about where the LLC that's going to own the property is formed? Now, the other LLC, James, that we have in the deal is for the manager LLC. Generally, that does not have to be formed in Delaware. My take on that is that should be formed wherever the managers are going to have their checkbook, because they're going to go in the bank, they're going to open an account. And if it's a Texas bank, the Texas is going to want to see a Texas LLC. If it's a California bank, they're going to want to see a California LLC, and they're going to want to see that that entity is formed in the state where you're doing your banking. Okay, but that's different than the property.
Okay. All right. So we have the interview with you, sort of go through the structure. And then, the question that I get probably the most or around syndications is really 506B and 506C.
Okay.
So
I've got
we can jump into that. Yeah. Okay.
I got a couple pictures I want to show you that's going to get us right into that. The first picture I want to show you, and I can't go without telling you, why the hell are you talking to me? Because someone needs to talk to a securities attorney when you're doing your offering. And this is a picture of a security. In plain English, when you have a bunch of members investing their money in an entity with an expectation of profit, James, and that entity and all the investors' money is being managed by the manager. So we have a whole bunch of passive investors, if you would, investing in this common entity, managed by the manager. That makes it a security. 4 prongs: investment of money, common entity, expectation of profit, managed by someone else. The government has an interest in policing those types of activities to protect the members. Now, in an LLC, we're called members and we're called managers. We're not called LPs. We're not called GPs. We're called members and managers. So that's a security, and that's a structure you see all the time, right, James?
Well, this is the structure, correct? And so if you have that structure as your, let's say, borrower, LLC, and everything.
This is the borrower.
That's the borrower at the top.
Yeah. Right.
Right. So then it's a security.
Right.
And I guess everybody wants to be exempt from that, from registering with the SEC. So
well, that's the rule.
Yeah.
The rule is that every security has to be registered with the SEC unless it's exempt. Okay. And there are really 2 ways to have an exempt security. Number 1, you could do it in an offering that's entirely in your state. That's called a Rule 147. If I'm buying a property in Texas, I'm in Texas as the manager. I'm formed in Texas. All my investors in Texas are in Texas. We could actually go to Texas law and do a private placement just under Texas law. Now, the Constitution says that the federal government cannot step into a state, 10th Amendment, and regulate business that's totally inside the state. So Texas has its own, if we're talking about Texas, has its own private placement law. So we could do that. But the problem with that is if you start setting up your entity just in Texas, inevitably someone says, well, Uncle Bob in Oklahoma wants to invest. And Uncle Bob's got $300,000. Well, your whole deal is screwed because you're going to cross state lines. You have to turn Uncle Bob down or you have to start over. So the other way to have an exempt security, exempt from registration with the SEC, is Regulation D. Another thing that's strong about Regulation D is let you write securities that preempt state law. There's no blue sky filing, if you know what that term is, in Regulation D. In the old days, before Regulation D, every time you found an investor from another state, you had to send all your documents to that state. They would look at it and they would either approve or ask you to change something or disapprove your offering. Blue sky filings in every state. Regulation D came along and the federal government says, we'll handle this. If anything goes wrong, they're going to come to us. They're going to come to us to complain. So we're in charge. We're going to preempt you from regulating, meaning preempt the states from regulating a Regulation D offering. So you don't have to register it fully with the SEC, and it's preempted from state rules. That's the best of all worlds. Well, in Regulation D today, the two areas, James, that that are most common, and there are a lot of rules in Reg D, but the ones we're asking about is, what about a 506B and a 506C, right?
That's right.
Right. Well, I'm going to jump ahead to a question.
Okay.
That I know you're going to have, just for the importance. In the last 12 months that the SEC collected information on these, and that's what the Form D is. We send a Form D to the SEC at the time that our clients get their final documents. Technically, there's a rule in how many days you have to do it, but we do it right away. And the SEC uses that form to gather information. The last 12 months of information that they gathered said that in Regulation D, there was $1.8 trillion raised in private placements. Okay. That's 5 times more than the IPO money that was raised on Wall Street during the same period of time. And this is about the same thing as an IPO. You start with no money and an idea, and you raise your money and go out and buy your property. Okay, 1.8 trillion. And over 95% of it is raised right here in 506B. Okay. Reg D came out in 1981 when I was a syndicator, and it really had rules that looked like the rules that are in this box. It was just simply Reg D Rule 506. That was what it was called. And there's no limit on the amount of money you can raise. You can have as many accredited investors as you want. And then they came out and defined accredited investors in 81. Because everyone, the point of 506 at that time was there's no advertising. You knew everyone. Your investors could just simply check the box and say that they were accredited. In 81, they started to allow you to take 35 sophisticated investors, which opened up capital formation. If there's at least one sophisticated investor, you have to have a PPM. That's the rule. And no advertising or solicitation was allowed. So that was the way I syndicated. And when the Jobs Act came along, Congress wanted to open up the process of capital formation. And what they really wanted to do is they wanted to say to Gene Trowbridge, Gene, you're out there raising money, and you can raise as much money as you want from an unlimited number of accredited investors. But you can't advertise for those. How are you going to learn who the accredited investors are? Everyone has to have a pre-existing relationship with you. That's hindering, Gene, your ability to raise money. And on the other side, all these accredited investors who would love to know about the self-storage projects that Gene are doing don't know anything about Gene because I can't find Gene anywhere. So they came along with 506C, and 506C basically is the same, except that now you can advertise for the purpose of capital formation. Gene can go out and use social media and do whatever he wants and find people that he doesn't know and offer them his investments, and maybe they'll invest with you. Same basic rules. You can raise as much as you want. You can have an unlimited number of accredited investors. But you probably have to, as the sponsor, take some third-party approach to be reasonably assured that the investors are accredited. You know, we can't stop where your advertising goes, but we can control who comes in the offering by being reasonably assured that they are accredited. No sophisticated. I still think you need a PPM because you have to give the investors all the information, and that's how you do it. Advertising and solicitation is allowed. Now, one of the reasons 95% of the money comes in here, as in here, is investors can self-certify. If you've been doing this for a long time, you have an awful lot of investors already in your database. Okay. If they're accredited, they're used to just going and checking a box that they're accredited, and you know them. Okay. So that's easy. If all of a sudden you come out with a 506C, James, and you tell your investors that they have to go through some third party and give up their tax returns and their bank statements and all that, they're not going to want to do that. So today, many of our syndicators have done many, many deals. And they know who their investors are, and they just do self-certification. I will tell you that my most prolific sponsor since 2014, I've done 134 offerings with this sponsor. 506B, accredited investors only, letting them check the box. Period. First of all, he doesn't need new investors. He probably gets referrals from past investors. That's fine. He builds a relationship, but he doesn't need to go out and advertise for investors. So I think that's very strong. When you say 95% and 5%, you can see that the acceptance level of 506 hasn't been as great as Congress wanted. In my world, new syndicators will go 506C. Because they want to advertise, they want to advertise, and they want to get new people in their database, James. Okay, so they advertise and they find a lot of new people. Not all of them are accredited, but you can still put them in your database. Develop a relationship, and then your next offering could be a 506B to people that you know. So that's kind of a strategy, especially if it's a relatively small offering. Then you just advertise the hell out of it for 90 days and you really build your database.
So I think when people are first starting, they have no idea between the 506B and 506C. And that was a great explanation between the two, because I think that issue comes up a lot and people don't really understand it well. So I think the next part of it is, okay, so from the syndicator's perspective, they choose 506B, 506C, and they're raising money from all over the country. So they put together a PPM. And what sections of the PPM would maybe the GP be focused on? And what sections should the LPs, people investing in these deals, they get a 90-page document. They're like, where do I start with this thing? Where should those people start in reviewing the PPM before they send it out? And then also, once they send it out, what should LPs be looking for?
Well, you know, James, I think the number one most important thing is who are the people behind the offering. So somewhere along the line in the property package, in the investment summary, there better be some biographies about the people. That's the number one most important thing. And I also think, and this is a little off topic, I also think the investors have a responsibility of educating themselves into the asset classification to which they're going to invest. If you're going to invest in apartments, the sponsor's not going to educate you on the apartment industry. But there are a million places out there you can go and get educated. You know, I see you at events. I go to events and there are people on the stage telling you how to invest in apartments. So I think that's important. If I was going to invest in self-storage, I'd go out and figure out something about the self-storage industry before I invest. I think the investors have a responsibility to do that, and they have a responsibility to learn about the people. But the private placement memorandum is the story. It's a disclosure document. It should be written in plain English, and it should explain all the things that you see on screen. Generally, I send that document out to my clients first, especially new clients. And we talk about everything that's in the PPM. And James, if I have everything in the PPM correct related to this offering, sure, there are some boilerplate sections in the PPM, but generally the PPM is specific to this offering. And I've been in court as an expert witness where the judge has said, I read this PPM and I can't tell you at all what property we're talking about. Well, as a sponsor, you're screwed. So it's a specific document telling the story. Then from there, we go to the operating agreement, which sometimes isn't quite as specific. It just has the rules on how we're going to run our business. So I've highlighted in dark blue what I think the investor should look at. And so if the investor should look at it, I think the managing member should pay some attention to what they put in the PPM for the story. And the first thing is the sources and uses. We're required to tell in a PPM an investor where the money is going to be spent. Let's say you're going to raise $3 million. You might have a $10 million loan. Well, the SEC isn't so terribly interested in the $10 million loan. The SEC is interested in where the $3 million goes. And because an investor, James, might be looking at 2 or 3 offerings at the same time, it's hard to compare just on the dollar amount. You may be looking at an offering where there's 5 million going to be raised or $1.5 million and try and compare the 3. So what the SEC says is, give us a chart where you can tell the investor where the $3 million is going to be spent. Legal fees, acquisition fees, then all the money that goes into the property, down payment, closing costs, lender fees, COVID reserves, whatever. Tell the investor exactly where the $3 million will be spent. And then, because the investor is looking at different offerings of different amounts, would you relate all that to a percentage? How much of this offering is going to go in acquisition fees? How much of this offering is going to go in down payment as a percentage? So you lay down 100% of where the money is. Now I can compare all the offerings I'm looking at to see where the money is going. And one of the major things is the load, if you would, the upfront fees that don't have anything to do with buying the property. I think there's a good rule of thumb for an investor that if the upfront load is more than 10% of what's being raised, I think you need to question that. That would be a standard. And I don't see that happening very often. But where it happens is when you get a great loan and you get great loan to value percentage, and the sponsor wants an acquisition fee based on the price of the property. Well, the acquisition fee might be 3%, and maybe we're getting a 95% loan. So that acquisition fee is so much of the money raised that it's problematic, I believe. So I just kind of think a 10% rule of thumb is great. So I think sources and uses is crucial. Distributions and fees. In plain English, the PPM should explain, during operations, what are we going to do with the money? At a capital transaction, refinance or sale, what are we going to do with the money? My advice to my clients are the sponsors, if you make it too complicated, no one's going to invest with you. And I know we're going to talk about that in a minute. It should be easy to understand, easy to write about it in plain English. Some of these clients that I have are whizzes at Excel sheets and this and that, and they come up with some of the greatest plans of all time. And I'm even confused. So I think you have to be careful. The next thing I think is voting rights. I think an investor, I think a member in an LLC needs to know what are they allowed to vote on and what authority does the manager have. More experienced managers take all the authority. The only thing the members can vote on is replacing the manager, which I think is crucial, and amending the operating agreement. Everything else the manager has control of. Beginning syndicators aren't quite as convinced that they can raise money, so they're a little more flexible. They may even give the members a chance to vote on the sale, on a refinance. That may be fine, but the members don't know. You know, the members are passive. It's the manager who's making the decisions. So what I see early on is I see inexperienced syndicators giving the members much more opportunity to vote, and the experienced syndicators not giving the members anything to vote on other than replacing the manager, which is crucial, and amending the operating agreement. Liquidity. 4 questions I think an investor should ask before they invest. James, if I give you my $50,000, what happens if something happens to you? Okay. So in the description of the business, you're going to talk about, James, the managing member entity, and you're going to tell me what the continuity is in case something happens to you. Very important. The next question is, James, have you ever done this before? All of us have had to say no the first time, right?
At least one time.
But I've done other things. Okay, so my advice to syndicators who have to say no is to do a small deal and get it over with. Say, hell yes, I've done one. Okay, just get it over with. So they're going to ask you, have you done it before? Third question they're going to ask is, James, are you putting any of your own money in it? Do you have any skin in the game? Then the fourth question they're going to say relates to this box. James, if I need my money back, what's the liquidity provision? I've heard that you can't get your money out of these deals. Well, that's not true. A well-drafted operating agreement has 2 provisions for liquidity for the investors. Number 1 would be a voluntary liquidity. Do I want to sell? Do I want to gift? Do I want to put it in my will? All those things. And you need to be able to read as an investor what your options are if you voluntarily want to give your interest to someone else. And then the second provision is involuntary. You get divorced and there's going to be a battle over assets. Well, we need to let you know that you can get out of this deal if needed. What if the investor has to file bankruptcy? Do we want this investment to be tied up in bankruptcy court, or is there something we need to do? What if the investor dies? How is that handled? So voluntary and involuntary, I think those are provisions that are important. So I think the sources and uses is important. The distribution and fees, the voting rights, and the liquidity. It's all important. And it starts with the description of the business and you knowing about the property and knowing about who the managers are. But James, you'll notice in my 4 questions, I don't ask, what's the NOI? What's cash on cash? I don't think I care if the manager is going to be a single person. I'm not going to invest in that anyhow. In fact, our company won't write offerings if there's just one person. Some lenders, and you know about springing members, some lenders require we solve that issue before they give you the loan. So you can't have just one person who has the authority to sign on all the documents, the only person who has the authority to sign, and it'll be in a situation where something could happen to that person. It's going to ruin the investment, and it's going to risk everyone's money. I'm a big believer in that. I've been a replacement general partner manager 6 times in my life, James, where other people's offerings were written where there's just one person and something happened. And it's a real can of worms to bring those people together into an ongoing situation where we protect their money.
So we've gone over 506B, 506C, we've gone over PPM stuff, key items to be looking for on the PPM. The sort of wrapping up a little bit here is I want to talk about when you're forming the sponsorship team and there's, let's say, somebody who finds a deal, there's somebody who, finds the deal, the next person maybe has multifamily experience, and then there's somebody else who's going to be in charge of capital raising. Can you touch on those people and how those people are compensated? And I think you had a slide on it, but that's probably the third question that I get more than any other question.
Well, now we're talking about this box down here that I call the enhancers. Okay, I only use that term because everyone uses different terms, key principals, sponsors, whatever. I just use enhancers. And here we have the manager. We have James and someone else in there, okay, for continuity. Now the lender says, boy, we don't have quite enough net worth in this manager entity. We need a balance sheet. So now I'm going out and looking for an enhancer, and let's use the term key principal. I'm looking for a key principal to sign on the loan. So the question is, James, right here, does the lender require the person who's coming in for credit or liquidity enhancement, does the lender require that person to be a member of the manager?
Yes.
And you could talk to that about in Fannie and Freddie. The answer to that is probably yes. It isn't always yes, but probably it is yes. So now we have to go up and when I'm writing this operating agreement, I have to make provisions for the enhancer to come in there. And that can be a negotiation, which we didn't plan on to start with, because an enhancer's signature on the loan is a value. It's a terrific value. What does the enhancer get paid for? How does the enhancer get compensated for that? Well, that'll be written in the operating agreement of the manager entity. So that would be good. Another enhancer that we run into is money raising. Someone says, well, I've got a guy or a lady who's got a lot of investors and they'd like to invest in our deal. Well, there are a couple of ways we can do that, but the most common way that we run into it is the money raising enhancer can't raise for your deal because you don't have a previous and existing relationship with their investors. So we have to take the money raising person into the manager LLC so that they qualify to bring investors in. And the qualification is called the issuer exemption. Just like real estate, you can, for sale by owner, you can sell your own house, you can sell your own apartment building, but you can't sell mine. So in the securities laws, it's called the issuer exemption. Everyone in here is an issuer, and everyone in here can sell the securities that are being offered by Investment LLC. But if you're not an issuer, the only way you can sell securities in Investment LLC legally is to have a securities license. And no one wants that. No one needs that. You just bring them into the manager LLC. Once again, here we go. That's something you need to negotiate. and modify the manager LLC agreement. So it's possible you're going to have a different LLC agreement in every deal, depending upon who these enhancers are you need in each deal. When I was a syndicator, I didn't need enhancers, and I used the same manager entity 16 times without changing it. But I find that doesn't always work today, especially for beginning syndicators who have changes in their structure on every deal. So, how do you compensate them? Well, you compensate them. I'm not going to talk about specifics, but I see cash. I see a cash payment. Investment LLC is willing to make a cash payment to an enhancer who brings their balance sheet in, because investment LLC wants to buy the property. And without that signature, they can't. So it's a value to investment LLC. Sometimes they just get units. The enhancer gets units in investment LLC. Maybe not the same type of units that all the members get, maybe some units, just like the members get, just for their signature. Maybe the enhancer, if they go into the manager LLC, gets a percentage of the manager LLC. Maybe the manager is taking 20% of the deal, and we need to give the credit enhancer 5%. I don't know. But those are the three: cash, units, or a percentage of the manager. Those are what you see, aren't they?
That's a great explanation. And I think what gets a little bit harder to distinguish is between like the SEC rules versus the lender rules versus what's negotiated between the general partners. And so those three things are different. And so people think they're the one and the same, like, oh, I didn't sign on the loan, so I can't get paid. Or I didn't raise equity, so I don't need to be, or I'm raising equity, so I do need to be part of the manager LLC. But then all the distributions are going to the manager LLC, and they don't necessarily want to pay that person, so they have to adjust the operating agreement. So I think there's a lot of nuances in there that you really need an attorney to go through and make sure your PPM is clear on where the money's going, and then also once you buy the property, how distributions are going to happen going forward.
Yes, James, and there's one other thing that we should talk about, because you're there just as a comment. The minute I set foot inside of the manager LLC, if I'm going to be an enhancer, and I set foot inside of the manager LLC, the first question I need to know, actually before I set foot in there, will I have to sign on the loan? Now, if I'm a KP, I'm going to sign on the loan anyhow. I don't care. But if I'm coming in for money raising or property management expertise or whatever, and I step into the manager, does that mean I have to sign on the loan? And that's a lender issue. It's not an SEC issue, it's a lender issue. And so they should ask that.
If they are the manager, if they have any management control of that manager LLC, then they probably do have to sign on the loan. Yeah,
absolutely.
Right. Yeah. Okay. I guess before we wrap up here, any sort of things that you've seen in the last maybe, I don't know, 3 or 6 months that you would just say, what were we thinking, or what was this guy thinking on whether it's the PPM, capital raising, SEC stuff, anything that you want as sort of a syndicator beware?
The two things I have seen: number one, asking other people to raise money for you, or other people coming to you and saying, I can raise money for you, and not doing that correctly. Number one, if someone's going to raise money for you, they should be an issuer. Okay? So they qualify for the issuer exemption. Alternatively, they can put together their own offering. And then with all their investors, they could bring one check and be an investor as one entity. The problem there is anything they do wrong in their offering let's say you're doing a 506B and they're out on social media trying to find people for their investment. That could blow your offering. All of their people would have to be counted toward the 35 sophisticated investor limit. There are all sorts of things that happen, but those are the two choices if someone's going to raise money for you. Now, recently, I had a client who had a little problem with that. And when they showed me the manager entity, which they formed themselves and they drafted their own operating agreement, they had 16 members, all of whom were expected to raise money. And each member had a contract with the manager group that said, if you raise X, this is what you're going to get paid. If you don't raise X, you're not going to get paid anything. There can be no compensation for raising money unless you have a securities license. Even if you're in the manager LLC, you might get part of the deal, but it can't look like a commission. The language is no transaction-based compensation. So if you're going to give someone 5%, they're going to come in and raise money. We don't care how much they raise. If they raise any or raise all of it, they get 5%, period. That's number one. The number two issue is the Ponzi scheme approach. When you're in a position where you're telling people you're going to give them a preferred return and you don't have enough money to give them the preferred return from operations, which is where it comes from. You go to the bank, you get interest. You get interest because you have an investment and they pay you interest, right? In your investment LLC, at the end of the year, there has to be enough money to pay the preferred return, or you go into an arrearages process, which is fine. Everyone has that in their documents. But here's the mistake that people make. Number one, they reach into their reserves, which they've got reserves for capital expenditures over the next 3 or 4 years, and they pull some money out of that reserve to make their distribution. They're actually giving people their own money back as opposed to giving them yield. So if you tell them, here's your 6% return, preferred return, you made 6% this quarter, and half of the money is from the reserves, that's fraud. You just lied to them. That's trouble. Number two, we ran into one person who just simply said, well, we're short of money for distributions, so we're going to sell some more units. 2 years down the road, they're going to sell some more units, pull the money in from new investors specifically to make distributions. I ever heard of Madoff?
Somewhat familiar.
Somewhat familiar, you know. And the person said, well, I told everyone what I was doing. Everyone agreed. Okay, I'm going to tell you that I'm going to shoot you right now. Okay, that doesn't make it right, does it? So that's trouble. You know, you can't raise money from new people to cover deals, cover agreements you've made with old people. So taking money from reserves to making current income distributions is fraudulent, and raising money from new people to pay off old people is a Ponzi scheme. There we go.
Well, I had my question. I forgot it all of a sudden, but it was going back to that first question. So maybe let's just be clear for people. So if somebody's raising equity on a transaction, they need to be in the manager LLC in order to qualify for the self exemption. Is that what it's called?
Or the issuer exemption.
Issuer exemption. Issuer exemption. Okay.
And in 506B, there's no advertising. You have to prove a pre-existing substantive relationship.
Right.
So if I'm going to raise money for you, but I'm not in the manager, you don't know who my investors are. You need me to be in the manager so I can claim the pre-existing substantive relationship.
Got it. Got it. Okay. Oh yeah, here's the question that I was thinking. So you're talking about some of these issues that people are running into. Um, is there anywhere for limited partners to search or find out about general partners? Because it seems like maybe a general partner did a deal 5 years ago, it went bad, but he's not raising money from those limited partners anymore. He's going to somebody new. And the new people he met this year, they don't know about that deal that went bad 5 years ago. So is there anywhere to find that stuff out besides Google? Or
I don't know, short of running a credit report and seeing if any of that showed up.
Okay.
I don't know of an answer to that. You can go to the SEC website and look at the Form Ds that have been filed.
Okay.
But and you might luck out and find the names of offerings that have been done. Like if you search me, Trowbridge Equity Group, LLC. If you search me now, probably 20 years ago, I don't think it's there. You could probably find all the deals I've done. But I don't know what good that does for you.
Okay, so when you
It's very
file
difficult.
when you file the form, that's all it says is how much you're raising, right? It doesn't
That's
really
right.
say.
And it's ahead of time, right? You have to file it within 15 days of raising the money, and then it's over. So there's no follow-up, there's no anything. And that's why it's important to start with who are you investing with. And I really don't know any better way than Google, some other name search type of thing. I've gone into, when I run into people who I know have done things wrong, there are websites out there that report legal action against people.
Okay.
And you have to sign up and you have to pay for those, and then you can do a name search. Credit report. Some people say, well, give me your credit report. Well, the sponsor doesn't have to do that. Okay. If I ask for a credit report and you say no, well, you won't get my money, but you don't have to give me a credit report.
Right. Like block out social and date of birth and send me your credit report or just bankruptcy search or legal search, any of that type of stuff you could ask for from the general partner. No, this has been great, Gene. I learn a ton every time you're on, and it clarifies questions that I always get. So I appreciate it. What is the best way for people to reach out to you if they have any questions or they're just getting started and might need a PPM done?
Okay, I'll tell you about that. For those of you who are looking at this today, the 4th edition of my book is just out, but it's only out so far in a PDF. I'm not at the point where it's hard copy where you can buy it yet on Amazon. I'm in that process. So what I could offer anyone who's watching this by scanning this QR is a free PDF, and automatically you'd get a free PDF if you go to that. So the best way to get a hold of me, there's the office phone number, and that'll be forwarded to me. Your call will be forwarded to me. An email, you can email me at the law firm. You can go to the law firm and sign up for a consultation with me. You can look at our YouTube channel. It's pretty good, Trowbridge Law. We interviewed you for Trowbridge TLG Talks, and your interview is on our Trowbridge Law YouTube channel. I think we've interviewed 37 people. Probably 30 of them are clients of mine who have been in the syndication business for a while. And a couple of them interviews are support to the industry, like you were support to the industry. Okay.
All right. Well, I appreciate your time this morning, Gene. Been a ton of great information. So definitely reach out to Gene if you have any additional questions or need to get started on your next PPM.
Thank you, James.
All right. Thanks.